Seinfeld Business Associations will be taught by Professor Carliss Chatman, the Serenity Now Foundation Chair of Business Law and Ethics at Yada Yada Law School and Associate Professor of Law at Washington and Lee University. Q&A for this class will be moderated by Professor Andrew K. Jennings, Susan Biddle Ross Memorial Professor of Law at Yada Yada Law School, and Fellow and Lecturer in Law at Stanford Law School. Professor Chatman, over to you for Business Associations with Seinfeld.
All right, thanks, Greg, and thank you so much for having me. I am very excited to talk to y'all today about Seinfeld Business Associations law. As Greg said, I am an associate professor at Washington and Lee Law School, where I teach all things business entities, M&A, securities, contracts and commercial law, and I also do an M&A practicum and immersion, some skills-based classes, and in addition, I do legal ethics. You can find me on Twitter at Carliss C, and I also have a personal webpage, professorchatman.com. Now, business entities law is a big topic. It incorporates contract law, economics, civ pro, property, torts, ethics, in addition to all things uniquely business in a legal context. We've got securities, fiduciary duties, M&A, business reorganization and bankruptcy. All of those things fall under the global business law umbrella. So when I teach the full version of this class to law students, what I often tell them is that it's a review of everything you did in the first year of law school, an introduction to some new concepts, and then also a preview of the things to come if you continue to pursue business law, as a practice or just in law school because you're interested. So my goal today is to give you a bird's eye view of business law. Then the next session, Professor Jennings will give you a closer look at securities. Now, what is a business? And, I like to say business is nothing that George is doing, because George likes to shirk responsibility and, isn't all that business minded. For our purposes, a business is defined as a sustained profit-seeking activity. And every business is a web with different connections and different players playing different roles, right? You've got lenders and owners who can be called partners or unit holders or shareholders, depending on what type of entity it is. You've got employees, suppliers, customers, the management. The name for management also changes depending on what type of entity it is. If it's a partnership, the partners are the managers. If it is an LLC, you can have member managed or manager managed. And in a corporation, it is managed by the directors and officers. You also have people I didn't put on this web. We've got, the regulators, the government who defines what the entity is and plays that role. A business could be owned by one or many people. And if owned by more than one, the vehicle by which those people own the business is called a business entity. And those entities are defined by state statutes, usually. Now, the state common law and state statutes gives us default rules. If you do not file any paperwork at all, and you are operating on your own, your business is a sole proprietorship. If it's more than one person and you don't file any paperwork at all, it is a partnership. The state statutes and the state common law also tells us what the relationships are outside of the statutes and any agreements. So if there are no agreements and a statute doesn't control, then the court is going to look at the scenario and make a decision. State statutes give us the definition of most business entities, but we also have some federal entities. But primarily, the influence that the federal government has on business entities is through securities and other regulations like the FCPA, the tax code. Those sorts of things are how the federal government gets involved with business entities. Every entity should have governing and organizational documents. In the statutes, you will find default rules for governance, and you also find some mandatory rules. In your contracts, your organizational documents, and your governing documents, you can alter those defaults that you're allowed to change. A good document Good governing documents can avoid many disputes. And you will see people operating in businesses with no documents at all. That's a horrible scenario, because that means a court's going to have to look at the facts and circumstances surrounding what you did and make a decision about how to define your business. Now, what I like most about business entities law is that it is very much founded in the spirit of American capitalism and our freedom of contract. So it's mostly a creature of state law and then private ordering through contracting. And we've got the federal government only stepping in when they preempt state law in those scenarios I talked about earlier. For our publicly traded companies, the companies you can go out on E-Trade or somewhere else and buy on the stock exchange, they have another source of governance in the stock exchange rules. These are the elements that distinguish one business entity from another. How an entity is defined determine who's an agent, who's a manager, which law governs, who gets profits, who's on the hook if the business does something wrong, and sometimes worst of all, who pays taxes. We find these definitions and the governing law in state statutes. Governing documents are what we create by contract. And then the business form will give us some of the basic management rules and the basic rules for liability exposure. From a tax standpoint, entities have an option of selecting corporate taxation, partnership taxation, which is passed through like individual. We have two forms of corporate taxation, S corps and C corps. And then, if you're a sole proprietorship, you just put everything on your personal tax forms. All right. So to illustrate what a business is and what it is not, let's consider the stock tip. Now, I know Professor Jennings is probably going to talk to you about this further when he talks about securities, but for my purposes, I want you to think about where the business entity exists, who is in business. So in this episode, George hears a stock tip on a great stock that is a must buy. The company's about to engage in a merger, and it has some novel intellectual property. So Jerry bites and buys the stock. Unfortunately, Jerry cannot deal with the volatility of the market, so he sells the stock before the big payday. George, however, waits it out and earns enough money to buy a Hyundai. He earns about $8,000. So the question is, are George and Jerry in business? Now, they are not engaged in profit-generating activity. They're profiting from the labor of others through the stock market. And what they're essentially doing is giving up some money. In exchange, they get shares or an ownership interest in the company. So as a result, George and Jerry are not in business. They are just investors. So if you think about the circle I showed you at the beginning, we talked about owners and investors. That's what their role is. And they're probably investing in a corporation. Now, you may wonder how I know that it's a corporation. Well, when Seinfeld was filmed in the 80s, it was before the second most likely candidate, the limited liability company, came into favor. So just using the process of elimination, I assume it's a corporation and that they are shareholders. The fun thing is things were a lot simpler in the 80s for law students when you had one less business entity to learn for the bar exam and other purposes. So our number one lesson of the day is that inventors are owners of a business, but they are not the business, at least in a corporation. It is always important when analyzing any business law hypothetical to consider what role someone is assuming when they take action. That determination, combined with the type of entity, will tell you whether they can be liable for the actions of the business or the other people, or if they manage the business, or what their role is in general. Now let's move on to agency. And when we talk about agency, what we're considering is who can act on behalf of a business. Now that you have a general idea of what a business is, we have to think about how businesses get things done. When you go get coffee at Starbucks or another restaurant, it's not the company logo that hops down off the sign and makes your coffee. It's also not the company charter that forms the business that prepares your order. It's an agent who is someone with the authority to act on the company's behalf. It's how these entities that are just, existing in paper, but still, considered legal persons. It's how those entities get things done is through their agents. Now, there are some risks to allowing agents to represent your business. One of the biggest problems is shirking. That's when, the agent takes your money and does not do what they're hired to do because they've got some freedom. You're not watching them at every moment and they can get away with it. We call this, doing whatever you can get away with. We call that moral hazards. There's no better example of a moral hazard and shirking than George Costanza and his nap desk. Now, George is the stereotypical slacker who does as little work as possible in the office. In season 8, George discovers that the best place to take a nap at work is under his desk. The only problem is those conditions are not ideal, not the most comfortable thing. Maybe people can see him. So he has Jerry's contractor make some adjustments to build him the perfect nap desk. Now, this scenario poses several questions related to agency. First, is George an agent of his employer? And if he is an agent, is he breaching his duties to the company by napping on company time when he should be working? Now, to determine if someone is an agent, I use something I call the ABCs of agency, right? It applies when there's an agency relationship, when a principal manifests assent, that's our A, to the agent, and that the agent shall act on the principal's behalf and be subject to the principal's control. And then the agent manifests assent or otherwise consents to act. And one thing I want you to notice about this, our C in my ABCs of agency is not contract, right? It is not contract. You can have an agency relationship simply by doing things and behaving a certain way. You do not need an agency relationship. You don't need a contract to form an agency relationship. Agency is a consensual fiduciary relationship that's created when two people agree that one will act on behalf of the other, right? It does require that the parties intend to form the relationship, but anytime you've got someone acting on behalf of another, a court may imply an agency relationship. So with this, with our hypothetical, George is an employee, which means that the Yankees manifested assent when they hired him. He consented to act when he took the job. He's subject to the control of his bosses, who are probably also agents of the corporation, which means that George is an agent and he has agency duties. Now, when we think about the duties that agents have, they have fiduciary duties. Now, this is just like when you go to work and you're expected to do your job and not take home the printer paper. You're not supposed to take home pens and pencils. You're not supposed to invest in things you hear about at work or take opportunities that were meant for your employer. Those are all duties that you owe your employer because you are an agent. As an agent of the employer, you owe them duties of loyalty and duties of care. These duties of loyalty include not taking material benefit from a third party, not engaging in conflict of interest transactions against your principal, not competing with your principal, not misusing of their property. And then when we talk about the duty of care, that's acting with care, competence, and diligence. And sometimes when we discuss concepts like care, we'll mention the elusive, reasonable person or a person who is similarly situated with your similar background. These are higher duties than you owe someone who you sign a contract with. A party who you contract with, you owe a duty we refer to as good faith and fair dealing, which means that you are honest when you negotiate and you act to uphold the terms of an agreement. An agent has to do something more, right? They've got to do loyalty and care, and many will read good faith into this loyalty and care in all circumstances. Now, I've mentioned good faith and fair dealing a couple of times, and I've also mentioned plain old good faith, and these concepts can be distinguished. Good faith is a concept that is read into every agency relationship, every fiduciary relationship, from partnerships, corporations, LLCs, a trustee, anything else that is fiduciary is gonna have good faith read into it. Good faith is somewhat hard to define. What it requires is acting with a conscious regard for your responsibilities. And it's just difficult to give you an exhaustive list of what's acceptable and what's not acceptable. But what it does require is that you have subjective honesty and honorable intentions when you act on behalf of your principal or whoever else you're a fiduciary for. It's sometimes easier to define something by what it isn't. And Jerry gives us the best example of what's not in good faith when he attempts to return an item for spite in The Wigmaster. Now, in this episode, we've got, Jerry buying a jacket with a crest on it. And, he takes Elaine with him to get the jacket. The salesman flirts with Elaine, doesn't really pay attention to him. And so because of that personal dispute, he wants to return the jacket for spite. Now, when he attempts to return it for spite, saleswoman asks him why he's returning it. He says for spite, and she says that spite is not one of the conditions that he can use for a refund, right? There has to be a problem with the garment, has to be unsatisfactory in some way, but spite is not allowable. He then has a conversation with her supervisor and says he wants to return it for spite. Supervisor says you cannot do that. So after that, he says, okay, then fine, I just changed my mind and I don't want it. And the manager says, no, you already said spite, that's too late, right? So this is the epitome of not in good faith and maybe bad faith. When he changes his mind, he knows that he's returning it for spite. He's not telling the truth when he says he has another reason, right? And spite is not an allowable reason. Spite is not good faith. So we get two lessons out of this little agency unit. First, agents can bind the business and act on its behalf. So you have to be careful who you select as an agent. You don't want to pick the George Costanza who's going to sleep under the desk at work. Other lesson we get out of this is that agents owe the entity fiduciary duties, including good faith. Now let's get into some entities themselves. Now we're going to talk about partnerships. And partnerships are one of those default entities that I spoke about. The general partnership is formed whenever two or more people operate a business, which means sometimes you can form a partnership by accident, and that is a very bad scenario for the accidental partner. Now, these are some of the elements of the general partnership. If you have a lawyer involved in your transaction or in your negotiations, you should never be forming a general partnership. Why? Because this form puts all of the partners makes all the partners jointly and severally liable for debts of the partnership. So that would mean, you're responsible for what your partners do. When they act on behalf of the partnership, you're responsible for a contract that the partnership itself breaches, and then you're responsible for the things you do on your own. So this is the worst case scenario in business entities, right? You are jointly and severally liable for everything. Once partnership assets are exhausted, you have to pay. Now, Elaine finds herself in a partnership in the Muffin Tops episode. While she's eating a muffin at J. Peterman's book signing, she mentions to her former boss, Mr. Lipman, who's also attending the book signing, that she only eats the top of the muffins and that a store that would just sell the tops would be $1 million idea. So Lipman starts a business called Top of the Muffin to You with the exclamation point, based on Elaine's idea. She's outraged that he steals the idea. So when the business starts to fail and he meets with her, he says that she can have 30% of profits. So then she gives him some advice on how to make the muffins properly. She explains to him that you can't just bake muffin tops on their own. You've got to separate the muffin top from the stump. It gives the business a boost, but it leaves a little bit of an environmental problem. How do you dispose of muffin stumps? They start by giving them to a homeless shelter. They try to have Kramer dump them at a dump. And eventually they end up having someone just come and eat them, right? They just find a cleaner to come eat them. So the question that arises from this scenario, how did Elaine and Mr. Lipman divide expenses and liabilities? Now, when Elaine agreed to join the business, they discussed profits, but they did not discuss losses. The default rule for losses would be 50-50, unless Elaine can prove that, in their agreement to split profits, they also intended to split losses at 30%. So because they didn't form a proper entity, because they didn't form any documents, they just did this all orally. If a homeless person got sick on the stumps, if there was a fine for the illegal dumping, if any other kind of liability arises, someone gets food poisoning from eating the muffins in general, Elaine could be personally liable once personal assets are exhausted. So you should never form a general partnership if lawyers are involved. You should find a way to form an entity that gives you some liability protection. So the lesson you get out of this unit is to negotiate terms clearly, to avoid finding yourself in an accidental partnership. Okay, and now we get to talk about my favorite entity, the entity I spend most of my time writing about, the corporation. And first, we're going to discuss how corporations are formed and how corporations are governed. Unlike the partnership that left Elaine personally on the hook for the debts of the company, an investor in a corporation gets what we call a full liability shield. That means that at most they can lose their initial investment. They don't lose anything more. So if we think back to Jerry and the stock tip, if he had invested in a partnership, he could have been on the hook for more than just his initial investment. But all he lost when he sold early was the money he spent on the stock. To maintain this liability shield, we have a separation of ownership and control, which means the corporation is managed by a board of directors who appoint or hire officers to handle the day-to-day operations. These officers are agents of the corporation, so they've got agency duties in addition to general fiduciary duties, but the directors are not agents. So all they owe are fiduciary duties. And I should say many officers also will have some sort of employment contract. So there can be duties that arise specifically out of what they're supposed to do by contract as well. When you form a corporation, you've got to file whatever document the state requires and pay a fee. So states call this articles of incorporation, certificates of incorporation, and charters. You got to file those documents, pay the fee, and then you've got to maintain annual reports, maintain formalities, and pay any state fees and taxes every year to maintain your corporate status. Now, Kramerica Industries engages in a lot of stuff, and you can't just form a corporation by accident. Kramer can't declare that Kramerica Industries is a corporation. If he doesn't complete the documents that I mentioned in the previous slide, all he will really have is a general partnership or a sole proprietorship. Kramerica Industries is Kramer's umbrella organization that does things like make your own pie. And in the Voice episode, he decides he's going to stop oil spills by making an oil bladder. Now, in the Voice, Kramer contends that the day-to-day work is what keeps him from growing his business the way it should. So to make it a real corporation and to make it a real business, he calls up NYU and hires Darren to help him out as an intern, to help him develop some of the previous idea. So he and Darren, work together to form this oil bladder that they throw out of a window, and unfortunately it does not work. Now, if Kramer had properly formed the entity to avoid veil piercing, which is when the court disregards the corporate form and treats it like a partnership or sole proprietorship, he would have to observe all formalities like having meetings, having directors and officers, keeping accurate books and records. He'd have to keep his funds separate. He couldn't just spend out of the corporate bank account like his personal bank account. And lastly, but not least, he cannot use the corporation for fraud. Deceiving NYU can kind of feel like a step towards fraud. And we don't see Kramer doing any formalities, so it is possible that Kramerica Industries is not properly formed, and if it is formed, he may be subjected to some veil piercing. So what does it mean if Kramerica Industries is not a proper corporation? And the biggest problem is who's on the hook when the oil bladder fails. If Kramerica is properly formed and the formalities are observed and there is no fraud, then just Kramerica is on the hook. Kramer doesn't have to pay anything. You exhaust Kramerica Industries, Kramer's off the hook. But if it is not properly formed, Kramer's on the hook. Now, our intern seems to be just an agent. He does not seem to be an owner of the business. We don't see a discussion of stock options or stock or anything else. So more than likely, he is safe and not on the hook. The lesson for this part: to take advantage of corporate form, you must follow all requirements for formalities, for formation, and you have to observe the formalities. Now, last but not least, we'll talk a little bit about the fiduciary duties that directors and officers owe a corporation. They're similar to what we discussed when we discussed agency. We've got loyalty and care and good faith. The difference with corporations is that it's a little bit harder to enforce these duties because it's hard to observe the day-to-day conduct of a corporation as a shareholder. If you're someone who's got an investment portfolio and you own a lot of publicly traded stock, no single company is worth the time it would take to just observe them with a microscope. It's also difficult because, you might own shares in Starbucks, or you might own shares in Nike or Apple, but you can't just walk in the Apple store and ask to see the books because you own shares. You've got to go through formal procedures to see books and records. Most investors are not involved in the day-to-day operations, and the management and operation is so far removed to what shareholders are allowed to do. To resolve this problem, we do have a duty of disclosure that's found in the common law where, it is your property, so they have to tell you things about your property. And then for publicly traded companies or, companies that fit within the securities requirements, we've got securities, mandatory and voluntary disclosures that can hopefully give those shareholders some insight into what's happening at the company so they can be on the lookout if fiduciary duties are being violated. So the chicken roaster episode, which is full of great material, but for our purposes, we'll be focusing just on Elaine and George. Elaine's behavior as the acting president of the Peterman catalog is a great example of what not to do when you owe fiduciary duties to the corporation as an officer. In her role as acting president at Peterman, she has fun charging a bunch of stuff on the account, mainly for her personal amusement, but also for her friend George. She buys George a sable Russian hat that costs $8,000. Corporations have what we call internal controls if it's operating properly. So they've got auditors, they've got accounting departments, they've got checks and balances on behavior. And unfortunately for Elaine, she falls prey to some of these internal controls when the accounting department calls her out for these impulsive charges. She's able to justify everything as a legitimate business expense, except for George's hat, which cost $8,000. Unfortunately, George decides to wear the hat on a date. He leaves the hat at the date's house in an effort to have a reason to go back. And when they call the date back, whose name is Heather, she claims the hat is not there. George and Elaine go to search for the hat. They cannot find it. So Jerry directs Elaine to a source for a replacement hat to make up for the one George lost. Kramer's friend, Bob Sacamano, who sells Russian hats in Battery Park. When Elaine goes to take the hat to the accountant and to make, to prove that, she has it, the accountant realizes that it is a substitute hat made of nutria fur and it is not sable. So Elaine is on the hook for this hat, committing a little theft, maybe some fraud, definitely breaching some fiduciary duties. So to try to save herself, Elaine goes to Burma to seek the approval of Jay Peterman himself, who also wants to see the hat before he approves it. So our question is, has Elaine breached her fiduciary duties? And the answer is absolutely, right? She has misappropriated corporate funds for her own personal amusement and, to help her friend George. And as I said, in addition to breaching fiduciary duties, she may have crossed the line to crime and fraud. So the lesson of this one is directors and officers cannot treat corporate funds like a personal bank account. If you take money or corporate opportunities, that is always going to be a breach of fiduciary duty. So that's the end of our lecture portion. Now we can do a Q&A.
All right, thank you, Professor Chatman. We do have a few questions that have come in. The first question is, what is the difference between an agent and an employee? Do all employees have a fiduciary duty to their employers?
So all employees are agents. All agents are not employees. And all employees are going to owe a fiduciary duty to their employer. You know that you can't steal from work, obviously, but you are supposed to go to work and do your job. The harder part is actually independent contractors. And the reason that it matters, I didn't talk about the tort liability and contract liability, but if someone is just an independent contractor agent and not an employee agent, then the company won't be on the hook for their torts. But if you are an employee and you are doing something in the course of business and at your job, your employer is on the hook for your torts and any contracts you breach as well.
All right, thank you, Professor. And our next question is, in a business transaction, are customers also required to act in good faith, or is that just agents? For instance, was Jerry's spite explanation for returning the jacket rejected because it wasn't a good faith reason for returning? And was the agent, the store manager, acting in good faith when he rejected Jerry's explanation?
So that's actually a great question. So Jerry, when you're a customer, there's a contractual relationship. And when you buy something from a business that is a good, it's governed by UCC Article 2, sale of goods. And so you do have an implied contractual duty to use good faith and fair dealing when you are buying something from a store. So while you don't have to act in good faith at the elevated level that the employee has to operate, you do have to operate with good faith and fair dealing, which is honesty and fact, right? So he is lying when he says it's not for spite. So therefore he's not acting with good faith and fair dealing. The employers are acting in good faith because they are stewards of the company, right? They are supposed to uphold all the company policies. And if return for spite is not one of the items that is listed as a reason for returns, then I think they were in good faith by refusing the return.
All right, and our next question is, does an agent who acts on behalf of a corporation have any role regarding the ethical and moral aspects of the corporation's decisions, or is that left to others?
So if you're an employee agent, the moral decisions are not your problem. You have to personally be moral. You're always supposed to be personally moral and ethical. I don't want to say that business people are unethical, but when it comes to like the decisions that are made for the corporation and the policies, the people who are going to be responsible for that are the directors and the officers. And so, that's why, if you observe, the stock market, or if you pay attention to, shareholder lawsuits, my favorite example of this is Facebook. The shareholders filed a lawsuit based on how Facebook was handling privacy concerns and how Facebook was handling information and how Facebook was getting involved in politics. The shareholders felt that, it wasn't moral, one, it was illegal. So the people who the shareholders sued were the board of directors for breach of their fiduciary duties and the officers as well.
All right, thank you. And our next question is, multiple corporations act together to do business, such as bidding on a government contract. They have no paperwork documenting anything. Are the corporations in a partnership?
So that's another great question. It really depends. Um, Most of the time, those corporations are going to have a contract because there have been cases that have found that those corporations are partners. And so, the time that arises most often, and that's the biggest deal, is you've got a group of companies coming together to like bid for a government contract. And one of those companies goes bankrupt and there's like an oil spill, or, there's a mass tort. And if they are partners and the court finds they're partners because they have no documentation, those other companies are going to have to pay the share of that company that is bankrupt. And so corporations that are savvy, and this is some of what I did when I was in practice, you would never let your client go out and form an accidental partnership. So if we're all going to get together to bid for a government contract, you'll sometimes see people form an LLC to do that. That is just like, a single purpose LLC for that purpose, or a limited partnership, which I didn't have time to talk to y'all about, but it's another entity that can give you limited liability. Other times they will just form a joint venture, which is just a contractual arrangement where you agree to work together for a limited time, limited purpose. And the point of that JV agreement is to make it clear that you are not partners. There's a recent Texas Supreme Court case that came out last fall. And, went all the way to Texas Supreme Court. I might have worked on it when I was in practice, or seen it when I was in practice. That's how long this case went on. But, the whole dispute was, the businesses said they were a JV. The other, the plaintiff said, no, you're a partnership. And the whole reason was they wanted to get to the deeper pocket that was the other company. So anytime you've got multiple corporations working together, there needs to be at the least a contract, and maybe you want to form a special entity to make it perfectly clear that you are not general partners.
All right, I think that exhausts our queue. I would like to thank Professor Chatman. Oh, it looks like we may have gotten one more question in. As a non-lawyer, I'm interested in the partnership arrangements at law firms. What type of business entity, if any, is a law firm considered, and are the partners agents, owners, management?
Oh, this is fun. So I spent a lot of time teaching this in my business organizations class. So partnerships are limited liability partnerships, LLPs usually. And what that means is that you form a partnership and you make a limited liability election. And all you have to do to do that, all you have to do to get a liability shield, is to check a box on a form you file with the state. Partners in a partnership at a law firm are usually owners and managers and agents. Like, they wear all the hats in a law firm. It is hard to find out exactly how partnerships are organized, law firms, unless somebody gets kicked out and they sue. So you can kind of Google around. I think there's like a Foley-Lardner partnership agreement online that is very juicy. There are some other law firm partnership agreements that were attached as exhibits to lawsuits before, some shield went up and took it offline. So you can find some of those before there was, an order in place for you not to see it. Now, what has become interesting about law firms is that we have these things called professional corporations and PLLCs. And so now newer law firms sometimes will choose the PC, professional corporation, or the PLLC. And there are some tax benefits to that. Like, if you make over $500,000, the PC is beneficial. It enables you to, have non-equity equity partners a little easier. And so some of the, more recent law firms are choosing PC, PLLC. But if you look at the AmLaw 100 firms that have been around for hundreds of years, those are going to be LLPs because the option of forming a PC or PLLC didn't exist when they started, and they're not going to convert form. I did briefly mention non-equity partners. So what that means is that it's someone who has management authority but doesn't have ownership in the business. how to figure out if someone is a non-equity partner is very elusive at a lot of law firms. They don't put non-equity partner on the website. They just call everyone partner. And so usually the only way you can find out if a firm operates with equity and non-equity is if you're able to get one of these lawsuit exhibits, because they've got these partnership agreements that are secret, that no one can see. And the last thing that law firm partnerships often do is they sort of mirror corporate structure in that they will set up a management committee. And so even though all of the partners, have the ability to sign pleadings and they have the ability to sign a check and can, do things in the ordinary course of business of the partnership, that's within their agency authority. When a firm forms a partnership agreement, that is done to give, a certain core group of partners the authority to do extraordinary things like, buy a lease, sign a lease, or, decide whether to take out a loan, or, whatever the partnership decides is appropriate. And then law firms will also have managing partner of each office as well. So they'll set up some hierarchies within the law firm, just so that each partner isn't equal, and you can signal to the public with a title, through the power of position, who may have superior authority to do things.
We have a follow-up question to that question, which is along those lines. It seems that some lawyers at big law firms, in Texas specifically, are themselves one-person PCs. Why do they do that, and what's different in Texas? Doesn't seem to be the practice in any other state.
So in any state, you can form a one-person corporation. And the reason that a lawyer would form a one-person PC is because it's kind of weird to have a one-person LLP. And you don't want to be a sole proprietor. You want some liability protection. And so a one-person PC is easier because one, if it's a one-person corporation, you can choose to be taxed as an S corporation, which means it's passed through just like a individual or a partnership. If it gets big enough, you can switch to C Corp, but you've got choices in taxation form, and you've got the liability protection. So it's just a way for a solo to get some limited liability protection without, having to call yourself a partnership of one. And some view the liability shield in a PC or a PLLC to be stronger than the liability shield in an LLP. I always give my students this disclaimer though. How liable you are as someone who is licensed, so an attorney, accountant, architect, engineer, etc., is not just governed by the partnership, LLP, or corporate statutes. It's going to be governed by your licensing authority. So you can never limit liability for things that you do using your professional license. So if you're an attorney and you commit malpractice, you are individually on the hook for the malpractice. Now, if you're an attorney and you form a PC and your associate or another member of your PC commits malpractice, that PC protects you personally from being on the hook for malpractice of the entire law firm or for other people in the law firm. But if you committed malpractice, you filed the wrong pleading, you missed a deadline, you let your client operate as a general partnership, and now they're on the hook for $1 billion of liability, you individually are still on the hook for that via your law license. And that kind of has nothing to do with the business entities law.
So I have one question. You mentioned during the lecture that during the 1980s and the early 1990s, it was really a corporation or a partnership or nothing. LLCs weren't really around at that point. If you were advising Kramer today in forming Kramerica Industries, would you suggest that he form a corporation, an LLC, perhaps an LLP with his intern? What might be some considerations he'd want to take in mind? And knowing what we know of Cosmo Kramer, what would be a good decision for him?
So if I were Kramer, I would form an LLC because all you got to do to form an LLC is fill out the paperwork, and you should have an operating agreement, but knowing Kramer, he probably won't. And, it's a lot more difficult to veil pierce in an LLC because formalities are not a requirement. There are no formalities for LLC. When I teach LLCs to students, I tell them, it's the epitome of cowboy culture. It's the wild, wild west of business entities. It is a pure creature of contract. It's got some elements of partnerships. It's got some elements of corporation, but the way courts are going to decide how things operate is going to be based on your operating agreement, which is just a contract amongst the parties. So if you don't have an operating agreement, you're not going to get in trouble for veil piercing the same way you would if you didn't have a corporate charter. So for people who are irresponsible, loosey-goosey, not into formalities, there are no officers you have to have specifically. You do have to file annual reports and pay your taxes, and what kind of taxes you have to pay are going to depend on what state you're in. But you're not going to get veil piercing because you don't have a corporate secretary or because you didn't have an annual meeting. So I think LLCs are great for solos. I also say LLCs are great when you know everyone. Most of the LLC cases that I have to teach look a lot like cases I would teach in a contract class, in that it's a contract analysis and it's bad drafting. And so, when you're getting into an LLC with strangers, or you're getting into an LLC with a big group of people, I often counsel people and say, are you sure you don't want to go ahead and form a corporation so that you've got things that you know? But if it's something like Cosmo, one person doing one-off things here and there, I would say LLC.
We have an additional follow-up to the discussion about professional corporations. What are the standards for a professional corporation? Is, for example, a sports referee a professional?
So the thing for a professional corporation is, it's someone who has a license, right? And they are doing business under the license. And in order to be a member or owner of a PC, everyone has to have the same license. So, maybe if sports referees are licensed and, they aren't allowed to do business with other people, and, in a business entity, then, they could form a PC. The biggest downside of a PC, or of just any entities at all, and, and engaging in your business under your license, is lawyers and accountants cannot form a PC together, and both be practicing law, right? Like if you're a lawyer and you're practicing law, only other people with law licenses can be partners, members of your LLC, or, shareholders of your PC. You are not allowed to make your secretary, a partner in your law firm, because the idea is that everyone in a PC holds the same license, has the same standards, they're upholding their fiduciary duties generally, and then you're upholding your ethical duties that come with whatever licensing authority you have. So you have to be, I think, I've seen lawyers get in trouble a lot with, I'm going to give my secretary some stock options and, in the company. And, if they don't structure it right, if they're also trying to be a closed corporation, which means you don't have to have directors, and so all shareholders are managers, and you give that secretary some stock options, you haven't violated business entities law, but you just violated state bar rules. So the other thing that I would say about a PC that is really, really hard, it's hard for me to give global PC advice for any type of profession, because licenses are governed by state law. And so you really have to check the law of every state where you are licensed. So I give that caveat of, I gave some broad generalizations, but maybe your state is different and I just don't know, right? So you absolutely have to check the individual law of the state where you are licensed to know who's allowed to be in your PC. And in the model code for lawyers, it has a rule about who can be, associated with a law firm. I've never actually looked at the accounting rules to see what they say, but, check the individual state. If you are a law student, don't go off practicing with what you use to study for the MPRE. Go check your individual state's ethical rules, because not all states have adopted the most recent updates. Some states are like, 10 or 15 years back on their professional conduct rules.
Professor, we have time for maybe one quick last question, which is a great one, which is, why is Delaware so beloved by incorporators?
Oh, I love that question. So I love Delaware. I love that question. Several reasons. One, Delaware has this court of chancery, and the people on the court of chancery handle sophisticated business cases. Most of them are ex-practitioners in fiduciary duty law and in corporate law. I mean, they're just so smart and awesome. So you get a bench, if you have a dispute, of judges who actually know what they are doing. When I practiced, I used to say, state court was the most terrifying thing for me, right? I want to be in federal court or I want to be in Delaware if my client is a corporation. So you've got an awesome judiciary that actually understands business, and you don't have to explain the difference between an LLC and a corporation when you're in Delaware court and why that operation is different. They're very well read. They engage with academics, great people on the Delaware bar, mostly men, a couple women. Other reason why Delaware is chosen and so beloved is it's got a long history of case law written by the Court of Chancery, which means it's good case law. It's got standards that everyone who does corporate law understands, and their statute is very favorable to management. A lot of the Delaware Code defaults are good for managers. And usually the people who are forming the corporation are going to be the initial managers. So why not pick the statute and the state that protects you the most? Also, their taxes are not bad. I don't do tax, but I've heard that some state fees are good, or are better. We do have some Delaware competition from states like Nevada that will allow you to waive more fiduciary duties. And you periodically have states try to step into Delaware's domain. But because they make it easy, they also, for LLCs, Delaware will let you keep your members secret. So you only have to say who the manager is, and then you don't have to give any other details about your LLC. You can also keep more things secret in a Delaware corporation, as well. So you get to keep things secret. The judiciary is very knowledgeable. They run cases through very quickly. If it's a Section 220 inspection rights case, those get expedited so fast, and you might be waiting a year or two if it were a different state court. And then just historical good body of law that everyone understands, and pro-management. Those are the primary reasons.
All right. Thank you, Professor Chatman.
All right. And so I forgot to mention, I know Professor Schill mentioned our fundraiser, but please do donate. It is a very worthy cause. And if you donate a minimum of $20 today, then you are entered for the raffle and get to go to the special event.
All right, thank you. And remember that this is a double header, so we will take a brief break and we will return with my class on Seinfeld securities fraud. And you can keep the current feed open. There's no need to reopen the window for that. Thank you all.